The Minnesota Workers' Compensation Court of Appeals is now in session. The Honorable Sean Quinn presiding.
Good morning, everyone. Be seated. All right. Today is Thursday, April 23, 2026. We have one case scheduled for today. Chmiel versus Cassia, file number WC 256628. In addition to myself, we have Chief Judge Millen to my left and Judge Carlson to my right. Remind everyone here that the argument is being live streamed and recorded. We would ask when presenting your argument, you speak loudly and clearly and into the microphone. I will remind you both of the timing rules. You have 15 minutes for your respective arguments. Each attorney will be given 3 minutes of uninterrupted time to start. Once those 3 minutes are up, I will interrupt you, stop you, and ask panel members and myself if we have questions, and then we'll just start peppering you until you wish you weren't here. It's up to each of you to keep track of your 15 minutes on the clock, on the dais there. The light will turn yellow when you have 5 minutes remaining. When your time expires, if we still have questions, we will just keep questioning you until we've run out of questions. If we give extra time because of extra questionings to one side, we will give the other side an equal amount of extra time. As to appellant counsel, you may reserve as much or as little of your 15 minutes for rebuttal. You don't have to tell me or tell the marshal, I want to reserve this much time. Just stop when you're done and you'll have whatever's remaining back on the clock when you're back up. When you step to the podium, identify yourself and your client. Mr. Kemet, you represent the appellant. You may begin.
Good morning. May it please the court. I'm Michael Kemet on behalf of the appellant Kathleen Chmiel. Your Honors, this case is really about two major issues. The first is the foundation of Dr. Cederberg's opinions with respect to the left ankle and low back. Those should be reviewed on appeal under the clearly erroneous standard of review. The second is whether the compensation judge properly applied the law regarding job search requirements to the TTD question that was litigated below. The application of law to largely undisputed facts is a matter which can be reviewed de novo. So going to foundation, Your Honors, the Cederberg report, particularly with respect to the left ankle, fails in three critical ways under the criteria listed in Hudson versus Trillium staffing. The first is it fails to include the facts and data on which it relied in rendering the opinion with respect to the left ankle. Although a expert needn't be given every single possible fact, enough facts must be given in order to render a reasonable opinion. Dr. Cederberg does not list in the 2025 report a single piece of treatment for the left ankle, despite all of that treatment existing at the time of the examination in January 2025. There is no foundation letter in the record about what records were given to Dr. Cederberg, so we're left with the medical summary provided in the reports, and there is no reference to any of the treatment for the left ankle. The report likewise fails to explain its reasoning on why a left ankle aggravation did not occur. It simply says, I don't believe so, regarding whether a left ankle injury occurred. And then he goes on to say, she has a long history of left ankle issues dating back to childhood. There is no attempt even made to explain why degenerative findings would eliminate the possibility of this being aggravated by protecting the right knee and favoring the left side. And further, the report assumes facts not in evidence. The report states that the employee suffered a left ankle contusion strain on the date of injury, September 13th, 2023. That is the single reference to any sort of injury to the left ankle on the date of injury in the entire record. Now, even if the court goes on to find that the opinion was properly founded, we're still left with that issue. Under Chmiel, medical expert opinions that conflict are reserved for the compensation judge to weigh. But when a medical opinion or a fact finding is manifestly contrary to the weight of the evidence, as it is here, Chmiel does not apply.
Okay, Mr. Chmiel, I'm going to interrupt you. We're past the 3-minute time frame, and I'll throw it over to Judge Carlson to see if she has any questions.
Thank you. Mr. Chmiel, you hadn't gotten to the job search issue, but I'm going to kind of get us there. I know there's going to be questions on where you left off. The defense in their brief, the first thing they bring up is saying that you have raised a new issue or a new legal theory on appeal, to the extent that you are claiming that she continued to be employed by the employer and had a reasonable expectation of continuing to work there. First, if you can comment on whether that legal theory was discussed and raised and argued below, and if it was or if it wasn't, if it's appropriate here on appeal.
It was absolutely raised below. Direct testimony was taken from the employee about her understanding of the nature of the relationship with the employer, particularly that she thought she was going to be able to return an accommodated role in the very near future. Likewise, in the exhibits below, the correspondence between my client and the employer representative, there's no other purpose for that to be entered into evidence other than to show the continuing relationship and continuing attempts to return to work as soon as possible, asking for accommodations.
And then my follow-up to that, in January of this year, this court issued a decision, Risa Jenko, that talked about this exact issue and when it may or may not be reasonably expected to return to work. Is it your argument that it was reasonable for your client to expect to return to work for Cassia? And if so, at what point would that reasonable expectation end?
Well, the reasonable expectation, I believe, would end when she stops communicating with the employer to try to get restrictions, and we have records showing, or exhibits, showing that conversation continued into March. At the minimum, based off of the memorandum from the compensation judge, it's not exactly a finding of the reasonable expectation and how long it existed, but at a minimum, TTD should be awarded from June 18th, 2024 through the August 1st, 2024 date that the judge listed in the memorandum stating that's when she started looking for work.
Thank you.
As to the job search issue, you didn't really talk about that in your brief. And you certainly appealed the finding of fact, but you didn't really talk about it in your brief. Are you waiving that issue?
Judge, I believe that the job search based on the facts in this case was not reasonably diligent below. And I believe the expectation of continued employment is my client's best chance at getting temporary total disability benefits for any period of time.
Okay, so then piggybacking on Judge Carlson's question about this reasonable expectation, as I understand it, your client needs left ankle surgery, right knee surgery, and bilateral shoulder surgery.
Correct.
And, working in sort of reverse order, it seems like the doctors are saying, regardless of causation, you got to have the right shoulder surgery first. Once you recover from that, then the left shoulder. Once you recover from that, then the knee. Once you recover from that, then the ankle, because you got to be able to use crutches and so on and so forth. Fair?
Exactly right, Your Honor.
All right. So if that's the case, and the employer is telling your client, given those ankle restrictions, we can't accommodate you, why is there any reasonable expectation that she's going to return to work there?
Well, as she said, giving testimony below, Your Honor, that she knows Cassia has sedentary work. They're just not giving it to her.
Okay, then what about, and it's near the end of the judge's findings, I could look up the number real quick, but, and it's a broad finding. I find the employee not credible. Now, I know that the judge can't possibly mean that every single word that came out of her mouth is incredible. When she said what her name was, the judge probably believed that. So what do we do with that credibility finding and this reasonable expectation issue?
Your Honor, you can still look at the exhibits filed without needing to find the client to be a credible witness. She is communicating with the employer, trying to get back with restrictions, and repeatedly getting met with, we can't accommodate, we can't accommodate, we can't accommodate.
Chief, you have any questions?
I do have one question. The Papa Inc., an online caregiver service app, you could have significant restrictions and still do that type of job. Excuse me. Correct?
It sounded like, given her testimony, that there were activities of daily living, assistance being given at that job. Sometimes it was very light duty. But occasionally there was assistance needed that would go outside of her lifting restrictions based off of.
If I go to the finding 3, that's what I'm referring to, it was an online caregiver service app. Employee was unable to work with Papa Inc. due to ongoing litigation between the online caregiver service app and the state of Minnesota. So it had nothing to do with any physical restrictions, correct?
That's correct. That job ended prior to the work injury at issue in this case due to that litigation and the app being basically frozen, so she couldn't bid for work.
So the compensation judge was incorrect that she was working 2 jobs in February of 2023?
She was working 2 jobs at that time,
Okay.
Judge. She was working at Papa prior to the work injury at Cassia, but she was briefly concurrently employed by both of them, although the compensation judge found that it was not included in the average weekly wage because it was too remote.
I probably am not being clear. My point is she could do that job with any physical restrictions that she carried that might make her ineligible for the job with this employer, Cassia. Because it's an online service.
Oh, well, it's an app-based service, Your Honor.
I understand.
But once she bids on a job, she drives to that individual and assists them with grocery shopping
Oh.
or activities like that.
Okay,
And some activities of daily living, toileting, etc.
so it wasn't purely online.
Correct.
Thank you.
Yes, yeah, correct.
And I have a question, getting back to the foundation.
Yes, Your Honor.
And you were talking about Dr. Cedarberg, and you set forth where the foundation was lacking. And I agree with you that Dr. Burt probably does more for explanation than Dr. Cedarberg does. But did Dr. Burt and Dr. Cedarberg have the same amount of information? Didn't they have access to the same records and review the same records?
Well, I know the Dr. Burt had access to both of Dr. Cedarberg's reports. That's in the foundation letter that I sent to Dr. Burt and admitted into evidence. I believe Dr. Cedarberg did not have treatment records for the left ankle because he doesn't cite any of them in the 4 corners of the report. And there's no foundation letter in evidence saying, Dr. Cedarberg, we provided you with these treatment records.
Okay, so you're not referring to, right, so before the date of injury, though, any records that existed before the injury, neither of the experts had those records, correct? Dr. Burt had them after the injury, but you're not convinced that Dr. Cedarberg had those? Okay,
Exactly right,
All right.
Judge.
thank you.
All right, so then address the foundation problems with Dr. Cedarberg relative to the low back that you see.
The low back case is not as strong as the left ankle. The fault, it fails by a single fault, and that would be the explanation. There's no resolution date. There is no basis in the records for the resolution date. Now, this might be a different case if Dr. Cedarberg gave an explanation indicating this is a so-and-so type of strain, and based off of this medical journal, it's expected to resolve in 8 to 12 weeks. That's a different case. He just chooses an arbitrary date for the resolution and does not explain it as is required in the foundational criteria.
Okay, so he had enough information to render an opinion. It's just that his opinion just doesn't make any sense.
Correct.
And he didn't explain it.
Correct.
Okay. Okay. All right, then, is there a reason why, going back to what Judge Carlson asked, is there a reason why there are no more older medical records predating the injury?
None of them were admitted into evidence,
Yeah.
Judge. I never was requested to provide those. The history of treatment is quite remote, approximately 10 years prior to the date of injury. And no treatment, no evidence below was entered suggesting that she sought or received treatment between approximately 2013 or 2014 through the date of injury. And then all of a sudden she starts treating.
Okay, and I want to say this the right way. The evidence of your client's prior left ankle problems then is whatever she testified to, which I think was, I had 2 severe sprains and I had a cortisone shot 10 years ago, 10 years prior to the work injury. And that's it.
Correct.
Okay.
Correct.
All right.
But after this injury occurs, we first get a medical record in September 2023, about, I believe, 2 weeks after the injury, where she begins to say, I'm favoring my left side because of this right knee meniscus tear, and it's making my left ankle hurt. And then there's no treatment for about 6 months until April, when she starts being seen for it as a major issue, and finally sees Dr. Davis, who gives an excellent explanation of the mechanical issues at play and how the exacerbation occurred. But briefly, Your Honor, I would like to just say, no matter what this court determines regarding the foundation of this report, the finding of the compensation judge that a contusion strain occurred, I'm out of time.
Continue.
The finding that a contusion strain occurred on September 13th, 2023 is manifestly contrary to the weight of the evidence, because there is absolutely no corroborating medical evidence in the record showing that such an injury occurred.
Go ahead.
Oh, okay. Well, finding number 5, the compensation judge, to your point, the compensation judge talks about the September 29th, 2023 date of service. And I'm going to just take from the middle of it. The employee describes compression pain throughout the back and down her leg, and pain into her ankle from limping to accommodate her knee pain. I think that's what you were referring to.
Correct, Judge.
Is that finding, that unappealed finding, is that consistent with a diagnosis of a contusion?
The medical record doesn't mention a bruise of any kind, Your Honor. And it's even in that record, it's a discussion of a gait change that is forcing her weight onto the left side. There was nothing below about a traumatic injury occurring to the left ankle on the date of injury. We are only talking about a aggravation of a pre-existing condition.
And I have one last question regarding the low back. You mentioned, Dr. Davis's opinion regarding the ankle, establishing, at least from your viewpoint, a clear causal connection between the limping and the ankle problems. We don't have anything like that relative to the back from the treating doctors, correct?
Correct, just Bert.
Okay. All right. Any other questions? All right. Thank you, Mr. Kemet. Mr. Larson, you may begin, and I think we went about 1.5 minutes, 2 minutes over time, so we'll accommodate you at least that much time if you need it.
Thank you. May it please the court, I'm Mitchell Larson on behalf of the respondents, Cassia Care Trust. The compensation judge, after a full evidentiary hearing, after observing the employee's testimony firsthand, after reviewing the full medical records as a whole as submitted to her, after listening to the arguments at the hearing, made 3 well-supported findings that the appellant asked the court to reverse, and we respectfully submit that none of those findings should be disturbed. The standard is Chmiel. The court does not reweigh evidence. It does not substitute its judgment for that of the trier of fact. And findings of fact should be affirmed unless they're manifestly contrary to the weight of the evidence as a whole. Here we have some competing inferences or some competing opinions from some of the doctors in the record before the judge. But under NORD, that choice must be upheld by the compensation judge as long as there's adequate foundation or as long as the record as a whole supports those findings. I want to go through the ankle issue more thoroughly. I think appellant is asking the court to pay attention to the contusion label in Dr. Cedarberg's report, and I think his attack is directed at the wrong finding. The finding is number 41, as we've previously discussed, but there's two separate conclusions in that finding. So the first is the temporary contusion finding made by a judge, while the second is the one that controls the legal outcome of this case, and that is that the employee's pre-existing ankle condition was not substantially aggravated. So those are two distinct conclusions in that finding, and the aggravation finding does not depend on the contusion label, does not live or die with Dr. Cedarberg's report. It rests on Cedarberg's report, but also on the record as a whole and the treating record that was available to to the compensation judge. And the treating record is what the appellant has not completely grappled with. We have the May 2, 2024 x-rays, which show chronic degeneration in the ankle. There's no acute fracture. There's a chronic degenerative deformity was shown. Essentially, the image shows a joint that with many years of accumulated pathology. And beyond that, we have the employee's treating orthopedic specialist, Dr. Mark, who documents a history of the employee's ankle complaints going back 5 to 10 years. That's nearly a decade before the work injury in 2023. And then Dr. Davis, the ankle specialist that the employee has chosen, diagnoses her with a symptomatic degenerative arthritis, and he says probably due to longstanding instability. And then he goes on to say that it's bone-on-bone arthrosis, again, saying that is longstanding. So twice in the same note, he's commenting on how longstanding this condition of the ankle is. And so the appellant's own expert is characterizing this ankle as this longstanding pre-existing condition.
All right, Mr. Larson, I'm going to stop you there.
Yeah.
And Judge Carlson?
Oh, thank you, yes. I understand your argument about contusion, the diagnosis of contusion versus the rest of the finding. But I want to talk about the contusion for a second.
Mhm.
The employee argues that the diagnosis of contusion, the only time you see that is in Dr. Cedarberg's 2025 report. Can you tell me, is there anywhere else in the record that you see a diagnosis of a contusion?
No, I don't believe there is anywhere else in the record where a specific treating doctor discusses or characterizes the injury as a contusion specifically. But I don't think that necessarily means that his report or his opinions are without merit, or that the record before the compensation judge as a whole didn't support her finding specifically on the aggravation issue.
And then you also heard Mr. Kemet argue that it looks like Dr. Cedarberg didn't review any ankle records. Is there any evidence that Dr. Cedarberg reviewed any medical records related to the ankle?
Well, what we do have in the record on Dr. Cedarberg's report is a list of the records that he did review. We do have the history that he documents throughout his reports, and we know that he examined the employee. He took his history from herself, and I believe he was able to. I believe he comments on the X-rays. If he doesn't, he still has the examination. He has the records before him. He has the history from the appellant. All of which provides adequate support for him to make a medical conclusion or a medical opinion.
Okay, I'll give the others.
But you know, Dr. Cedarberg, he actually doesn't do that regarding the ankle. In the first report, he lists 7 different providers that he reviewed medical records from, without like saying from this date to this date, just a list of places. And then he goes through about 9 or 10 of them, and none of them are the ankle ones, with the exception of the Dr. Ames visit on September 29, 2023, but he doesn't mention that she complained of ankle pain in that note. So the ankle is not mentioned anywhere in that first report. And that kind of makes some sense because he wasn't being asked about the ankle then. But in the second report, he doesn't have a list of medical providers at all, and he just mentions a couple of treatment notes. None of them are the ankle ones, including the x-rays or the MRI. So, I mean, Mr. Kemet makes a good point. We don't have any evidence that he reviewed any ankle treatment at all. Is there any evidence that he did?
I don't think there's any explicit evidence that that in the record that he necessarily reviewed the records. He does discuss in that second report, I believe he discusses the diagnosis of degeneration in the ankle. So that comes from somewhere, and implicitly he would have had to review a record to identify that prior diagnosis. And again, look, is Dr. Cedarberg's report a little thin? I would agree. I would like him to expound more. But beyond Dr. Cedarberg, there is ample evidence beyond his report in the medical record to support the compensation judge's findings.
All right, well, tell me what that is, because what I see is Dr. Cedarberg probably not having foundation for the ankle. I would agree that Dr. Burt's opinion, as outlined in your brief, is pretty weak on the ankle too. But then now we're left with pretty much Dr. Davis, who says long-standing degenerative condition, bone-on-bone arthrosis, which we all know didn't happen the year before. But he also says substantially aggravated by this limping. Do we have anything else?
Well, again, I think the record as a whole, the employee's testimony, which was found to be uncredible, we have the treatment records. Again, we have the May X-rays that show chronic degeneration. We have Dr. Davis and Dr. Mark both opining that this is longstanding. Then we have Dr. Cedarberg's opinions. Taken as a whole, the compensation judge was able to review all that, review the opinions of Dr. Cedarberg in conjunction with the testimony of the employee with regard to her ankle, in conjunction with the rest of the medical records that she was able to review, and find that what we have here is a longstanding degenerative issue. It's bone on bone. And what we have is a symptom flare of symptoms in the ankle. You know, increase in symptoms does not automatically lead to a substantial aggravation. And in doing so, and in weighing all the evidence before her, she found that there was no substantial aggravation of that ankle. And I think there's more than enough evidence in the record to support a reasonable conclusion on that basis.
Okay. Then what do you have to say about the low back?
Yeah, with regard to the low back, so we have the November 23 lumbar MRI, which basically says there wasn't any significant differences between the November 2023 lumbar MRI and the 2020 MRI from prior to the injury.
Which we don't have.
But
Correct?
Correct.
Right.
But the 2023 record says it's essentially the same.
Right.
And there's no significant changes. And then we have, I think it's finding 11. It's a Dr. Kaiser. She goes and sees Dr. Kaiser a month after that. I believe it's December 13th, which is the day of the MMI. And he says, look, there's nothing much I can do for you with regard to treatment for the low back. Specifically, I think it has to do with some of her allergies to some of the treatments available. But you take the patient as you see them, and that's exactly what MMI is. You've reached maximum medical improvement. There's no more treatment available to improve upon that condition. That is what MMI is. It doesn't matter that she continues to complain of low back pain beyond that. I mean, that's fully within our legal definitions and medical definitions of MMI. You can still have complaints of pain. It's whether or not you're expected to improve. And even when you reach MMI, employers and insurers are expected to, pay for that treatment that's available to keep her at that plateau or relieve her pain.
Well, there's a difference between MMI and a resolved condition, however, correct?
Agreed.
Okay, so the compensation judge found resolved. And it seems like Cedarburg picked a date that was exactly 3 months after the date of injury. And it coincidentally happened to be a date of Dr. Kaiser's visit. So I agree with you what Kaiser said, that there's not much I can do for it. And unlike the Dr. Davis report on the ankle, we don't have much after that regarding the back either that I saw. On the other hand, there's no real solid explanation from Dr. Cedarburg why he picked this date. True?
True. Again, I think Dr. Cedarburg, I think everyone would appreciate if Dr. Cedarburg would be more thorough in some of his analysis and his reports. But again, that goes to the weight of his reports, not necessarily to the foundation. And Judge Walder weighed all the competing opinions on that issue. She looked at the evidence before her, and she determined, and I think she probably made that basis on Dr. Kaiser's note there on December 13th, and the fact that the MRI showed that there was no changes from her previous MRI 3 years earlier, to say that, look, if there was anything that happened to the back on that date, it was a temporary one, and it was resolved on that point when she made that MMI determination.
What's your take on the temporary total issue?
Yeah, first of all, I think I think we win on two independent grounds on that one. The first theory is that it was not litigated at hearing. Sure, there's evidence that suggests, you could make a determination that there was some sort of reasonable expectation by the employee based on the exhibits and some of her direct testimony, but the actual legal theory was not presented to the compensation judge.
So Mr. Larson, the issue in front of the compensation judge, I believe it was issue number 5, is whether or not she's entitled to temporary total disability benefits.
Correct.
So then your defense to that apparently was job search. But wouldn't exceptions to job search also flow from that? And do you agree with Mr. Kemet that these questions regarding ongoing contact with the employer, that evidence was presented? So it seems to me that it all kind of flows from the issue. So at what point do you think the line is drawn where, well, no, you can't make that argument now? I'm not really understanding that.
Yeah, well, I think it's substantially similar to the Luthard case. That was the Supreme Court case from 2021, and in that case there was this court remanded on the rare exceptions for the treatment parameters rules, and it was they said that this court said that the compensation judge should have considered that rare exception rule. The Supreme Court reversed that decision because it said that legal theory, that specific legal theory on the rare exception, was not raised to the compensation judge. And so in that case, we have a general issue of entitlement to medical benefits or entitled to medical treatment under the treatment parameters. And then you have the narrow legal theory of that rare exception where it would apply. And here we have entitlement to wage loss. It's the general issue that was before the court. Job search, general issue. There's that rare exception that can apply sometimes when there's a reasonable expectation. That legal theory was not submitted to the compensation judge. And so it's the same, just as in Luthard, it would be in this case. They didn't raise that legal theory, and for that reason, it shouldn't be appropriate to have it appealed here. Even if you get to the merits, though, I think we still win on the merits. The finding 34, it's an affirmative factual finding that the employee previously believed she could return to her position with the employer. That's past tense. And I believe she's making that remark regarding a period before August of 2024. So that's the compensation judge acknowledging that the claim belief and in any claim belief that she had a reasonable expectation had ended at that point. So we have a finding based on the employee's testimony at the trial and the hearing that any reasonable expectation ended at that point. And then right after that, you have finding 35, which makes a global credibility determination against the employee. And I think if you read those in sequence, and if you read the transcript, specifically in that area where we're on cross-examination regarding job search, those two findings tell the story. The judge is considering expectation evidence.
Well, it seems to me that maybe you and Mr. Kemet are agreeing that it's, excuse me, from June through August, that there might be a reasonable expectation that she could return to work with the employer. Do you agree?
There might be. Again, I don't think it's very clear, explicit by that finding exactly when that she previously expected to return to the employer ended, whether that was in, in June to August or even further before that. But, again, I think that the rule on reasonable expectation, it's a permissive rule. It allows the compensation judge to use that as evidence to excuse job search, but it's not a hard legal line where whenever there's and again, to have it has to be a subjective reasonable expectation to return to work with Cassia. Well, we just have a determination from the judge that they don't find her credible. So how, if you don't find her testimony on job search, on her expectations credible, how can you have a finding that she subjectively had a reasonable expectation to return to work with Cassia?
Questions, Chief?
No, thank you.
You've 10 more seconds if you'd like to wrap up.
I have nothing further. Thank you.
Right, thank you, counsel. And thank you both. The record is now closed. This court will issue a decision within 90 days of today's date, and we are adjourned.
All rise. Thank you.
Good job, man. See you around.